that gave rise to the indictments appearing before you today. Unless Your Honor wants a summary, I will not repeat them. It's certainly been discussed publicly in this courtroom before Your Honor.
Right.
And to save...
I don't need a summary. What are you suggesting as conditions?
Your Honor, we're looking for stayaways again. One of the problems we've had, Judge, and I've spoken to Mr. Bradle about this several times, the defendant has, in the Commonwealth's opinion, continued to violate the original conditions of bail, including those that were amended by Your Honor. If Your Honor were to look at the video provided, Mr. Bradle has received a copy as well of the thumb drive. It's clear that Mr. Kearney is encouraging his minions, his followers, in the context of his blogs and YouTubes, etc., to continue to harass witnesses. He'd make a statement such as, "I can't do this, and I'm not telling you to do this, but you can do this, but I'm not saying you can't do this. Don't put words in my mouth. You know, read between the lines. Read between the lines on approaching these witnesses." And he's made similar statements several times, and it's the Commonwealth's contention that this is a very disingenuous way that the defendant is indirectly encouraging others to indirectly harass these witnesses and to intimidate these people and pick it in front of their homes, etc. What I can represent, Your Honor, is that we had the grand jury proceedings underway. The Commonwealth was aware that most likely this matter would be before Your Honor or before the Superior Court in relatively short order. We did not proceed with bail revocation in the district court. However, I can assure Your Honor that would like the defendant to be on notice that if there's one more instance where he is online suggesting to people or encouraging people either directly, disingenuously, or whatever the case may be, and encouraging in some way to read between the lines, that we will be back before the court seeking a bail revocation as well as a dangerousness hearing. I would ask Your Honor to fashion some type of order that Your Honor believes would be effective in precluding this defendant from going online and encouraging his followers to essentially continue his pattern of intimidation.
What specifically are you asking me to order?
Judge,
you're asking me to write it.
I'm sorry?
What do you want me to say?
Well, that he should not encourage, intimidate directly or indirectly to have his supporters or encourage his supporters to approach witnesses.
That's what the district court said. You have to stay away and have no contact with the witnesses directly or indirectly.
I think perhaps language that prohibits him from encouraging others to do so. Judge, it may come as far as not even mentioning the names of the victims that appear here. I certainly understand that there are First Amendment arguments that are being made, and we're extremely sensitive to that. We're extremely sensitive to the fact that the defendant claims to be a journalist covering the case involving Karen Reed. We're aware of all of those things. However, the lines blur, the lines cross, and he is hiding behind the guise of a journalist, encouraging basically as an activist. And when he's doing so, that's what we're going to ask Your Honor to preclude him from doing, and perhaps preclude him from mentioning the names of these particular witnesses in a context that would encourage others to approach them or communicate with them. I know it's very difficult. If you see it, you know what it is, but it's very difficult to define it. And I think it's extremely disingenuous of the defendant to say he's not engaging in it when he's saying...
Hold on one second.
All forwards off, please.
Go ahead, Mr. Miller.
Thank you, Your Honor. I think it's extremely disingenuous of this defendant to say, I'm not encouraging this, when he's using terms such as read between the lines.
Okay. All right, Mr. Bradle.
Thank you very much, Your Honor. We would just maintain our objections that we've earlier made before the court as to stay away orders on probable cause, First Amendment, and due process grounds. Ask that you just maintain that for the record and in the record in terms of our objection. As to any prior restraint on Mr. Kearney's speech, you know, counsel for the Commonwealth is having trouble articulating it because it's such a problematic area, I think, that, you know, how are you going to do this? Mr. Kearney has a First Amendment right to encourage people to exercise their First Amendment rights. I've advised my client about the notion of indirect contact. When you tell someone to contact someone you can't contact on your behalf, that's indirect contact. He can tell people under the First Amendment, if you know, he can share his views with his readers or his viewers, and they can do what they want. He's allowed to encourage them to speak out against what he sees as corruption, what he sees as mismanagement of the Reed case, et cetera. I've advised him about the notion of indirect contact. We have a disagreement, counsel and I, a respectful disagreement apparently, about what constitutes violating these orders. These orders are, in effect, prior restraints on his First Amendment activity, Your Honor. So they must be narrowly tailored and strictly construed. And in this case, we've discussed it. My client and I think we know as best we can what can and can't be done. In terms of speaking out, that's not harassment, that's not witness intimidation, that's journalism. And it's cloaked by the First Amendment, Your Honor. So I would object to any attempt to sort of craft a prior restraint here, Your Honor. And we'd object to any sort of effort in that regard for the record.
Your client consents to the stay away, no contact, direct or indirect with the various victims.
We don't, Your Honor. We
don't.
We object for the record.
You object.
Yes. Yep.
All right. Mr. Mello, under what statute do I have the authority to compel Mr. Kearney to stay away and have no contact with the victims?
Well, Your Honor, it's common practice, as Your Honor is aware.
I'm not talking about common practice, Mr. Mello. I'm talking about what statute authorizes me. This is not a district court proceeding, which is subject to Section 58 of Chapter 276. This is a proceeding under Section 87, of 57 of Chapter 276, or I have authority under Section 87 of Chapter 276 to impose conditions with consent. You don't have to ask for personal recognizance. You can ask for bail. You can ask for dangerousness if you think that's appropriate. But under what statute do I have the authority to set conditions to which Mr. Kearney does not consent?
I believe that, well, obviously, Your Honor, you would have to sign the terms and conditions of bail. We could do that through through the context of a dangerousness hearing, which the Commonwealth prefers not to employ at this point in time.
You haven't moved for dangerousness.
I'm sorry?
You haven't moved for dangerousness. You haven't invoked 58A.
Right, we have not, Judge.
Right. So what statute authorizes me, absent Section 58A, to impose conditions on Mr. Kearney's release, if you're asking or consenting to personal recognizance?
I think,
or even if you're stipulating to a particular bail. Section 87 is different than Section 57 is different than Section 58.
I understand that, Your Honor. I think in total, both Sections 57 and 58 would give Your Honor the authority to impose certain conditions, especially when it comes to the witnesses. What I think the challenge here, Judge, is we have competing interests in each other. We have the competing interest of a claim of journalism and First Amendment.
You said 57 and 58 together give the court authority.
I
Section 58 applies to the district court, right? And Section 57 applies to the Superior Court, right?
Correct.
And 58 has a provision in it that says, if the judge, I'm going to paraphrase now, of the district court determines it to be necessary, the defendant may be ordered to abide by specified restrictions on his personal associations or conduct. I quote that now to you in Section 58. I quoted it before in my earlier decision, right? Section 57 has no such provision, right?
I would argue, Your Honor, that although it indicates that the district court judge may do it, certainly comes under the purview of the Superior Court. I don't think the intent of the legislature was to narrow the authority of this particular court and make it less than that of the district court. It's normally that these matters are instituted in the district court before they arrive at Your Honor's level. And I believe that's why the legislature perhaps put that language in, but I don't believe it precludes this court from doing so either.
You have a case that says that? I mean, the
I don't,
statutes are
Judge.
different.
I wasn't expecting.
You came in asking me to set a set of release conditions that you knew Mr. Kearney wasn't going to consent to. He objected to it before in the district court.
Judge.
I think the district court was entirely within its power to set that condition, and it was appropriate for me to uphold that condition. I think it's an appropriate condition to be imposed in this case, in the Superior Court, but I don't know if I have the power to do it under the statutes, and I'm looking for some authority that you might have indicating that I have the power to do it.
What I would ask Your Honor to order is that he comply with all laws. The general provisions when someone is released on bail, the Commonwealth will take it from there if there's a violation.
If he's released on bail, he doesn't have to sign anything with respect to personal recognizance, right?
No.
You're asking me to release him on his personal recognizance, right? You're not asking for me to set bail, and you're not giving me any authority to indicate that I have the right or the power to impose conditions on his release.
I would suggest a dollar bail, Judge, if that's what.
Well, excuse me for a second. I have the power to impose conditions of release under Section 87, including stay away, no contact orders with the defendant's consent, right?
Understood.
Okay. So.
I mean, I realize I could appear before Your Honor asking for a high bail, which I don't believe the Commonwealth would be honest to do. We don't expect Mr. Kearney to not appear, at least at this point in time. The normal condition of release, Judge, would be that he comply with all statutes. If Your Honor is not inclined at this point in time to fashion an order, the Commonwealth certainly appreciates the court's position.
I don't have to order him not to commit crimes. If he commits another crime, he'll be in front of the court on a violation notice. And I don't have to order that. He's already subject to the law as everybody else is.
So we would indicate that's an indirect violation, and we would proceed back in court, Judge. I'll accept Your Honor's ruling.
Okay. Anything further, Mr. Bradel?
Nothing further, Your Honor. Thank you.
All right. All right. I'm going to, on the Commonwealth's recommendation, release Mr. Kearney on personal recognizance. The Commonwealth not now looking for bail. I do find that the Commonwealth has asked for conditions to be set on Mr. Kearney's release, but the Commonwealth provides me with no authority that I have the power to do that over Mr. Kearney's objection. The statutes are a little bit convoluted. General Laws 276, Section 87 allows me to set conditions on release if the defendant consents to those conditions. Here, Mr. Kearney doesn't consent to those conditions, and the provision in Chapter 276, Section 58 Paragraph 1, last sentence, which I quoted before, authorizes the district court to set conditions on personal association or conduct, including avoiding all contact with an alleged victim of a crime. That provision does not appear in Section 57, which is the provision that applies in this case for the setting of bail in the Superior Court. And while that provision, Section 57, authorizes the setting of conditions in 209A and related type cases, this is not one of those enumerated in Section 57, which allows me to set conditions on Mr. Kearney's bail over his objection. This is a bail setting under the first paragraph of Section 57, which does not have the same language as in Section 58. So I am hamstrung, at least with the authority given to me by the Commonwealth. So I'm going to release Mr. Kearney on bail. He knows that if he commits a crime, he'll be back in front of the court in quick order. So you'll make sure of that, Mr. Mello, I'm sure. Anything else? We need a pretrial conference and a pretrial hearing date.
I would suggest something in February for pretrial conference, later February.
February 7th, all right, for a pretrial conference?
Is that okay?
I would ask for the 16th.
16th, sure. Oh, I'm going to be, not a good week. Could we, actually, no, 16 is fine. February 16, that's fine.
And then something in April for pretrial hearing?
Also the 16th. Does that work?
April 16th, Tim?
April 16th?
Yeah.
I can't do it, I'm sorry. Could we go to the following week?
Sure.
The 23rd?
Yes. Is that okay, Mr. Mullin?
It is.
Yeah. Mr. Kearney, you're being released on your own personal recognizance. Please be advised, allowed on personal, if you're arrested for a new crime, you can be held without bail for up to 90 days, and your failure to appear at a court appearance can result in a fine of up to $50,000 and/or 5 years in jail. Your matters continue to 2/16 at 2 p.m. for pretrial conference and 4/23 at 2 p.m. for pretrial hearing.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you, Mr. Clerk. Thank you very much, Ron.
All rise, please.
No, no, no. No terms of release, no. Straight. No, no. He just mentioned.